Hey real estate professionals, welcome to Velocity Title's Title Minute. Today, our expert real estate attorney, Glenn Donaldson, will be discussing the importance of choosing the right type of deed. Afterwards, we'll share our contact info and you can submit any questions or comments you might have and we'll get back to you as soon as we can. And now, here's Glenn.
Thanks again, Lauren, and welcome back everybody to the Title Minute by Velocity National Title Company. I'm Glenn Russell Donaldson, your real estate attorney. Today I want to get right into it. Title deeds. One of the things, if you're a real estate professional, that you're going to want to do when you get to that settlement table is you're going to want to make sure that you've looked at the ALTA settlement statement, that you've looked at the closing disclosure, that the numbers all match. By doing that, of course, you're protecting your client's interests. Beyond that, you also want to make sure that you have looked at the deed for the type of deed that's being used to convey the interest from the seller to the buyer, your clients. Let's touch base on the four types of deeds very quickly. Quitclaim deed, special warranty deed, general warranty deed, and life estate deeds, sometimes used for estate purposes. For our purposes today, we want to focus a little bit on the quitclaim deed, special warranty deed, and general warranty deed. Now, the quitclaim deed is where the seller is conveying what interest they have in the property, if any. They make no warranties whatsoever that they even own the property, and whatever interest that they do have, if any, they're going to convey without warranty to your buyers. You really do not want to sit at a settlement table and see a quitclaim deed being executed by a seller into your buyers. The second deed we talked about was the special warranty deed. The special warranty deed does have some warranties from the seller, but those warranties are limited. They're limited to the period of time in which the seller owned the property and nothing before. So if there's a claim on title during the seller's ownership, there's going to be warranties the seller's going to have to protect your buyers for. But if that claim came from a prior owner or before, which frequently it does, that seller has no obligation to warrant or protect your buyers. Lastly, and what you're really going to be looking for, is that general warranty deed. It has the most broad protections for your buyers. It in fact warranties from the seller to the buyer that they'll protect the title from their ownership and beyond in perpetuity forevermore. So if there's a title claim that arises from 2 or 3 prior owners, that seller that transferred to your buyer still has to protect your buyer's interest in the title. This is not to be confused with title insurance. That'll be for another day. If you have questions on that or anything else, please contact us at contractquestions@velocitytitle.com. That's contractquestions@velocitytitle.com. Or please feel free to reach out to our new contract hotline at 1-800-MY-RE-LAW. That's 1-800-MY-RE-LAW, 1-800-697-3529. I didn't forget about that life estate deed. We'll talk about that in another day.
Thanks again for joining us for Velocity Title's Title Minute. For exclusive access to additional content, be sure to follow us on Facebook, LinkedIn, Instagram, and make sure you subscribe to our YouTube channel. You can also contact our office at 301-805-2900 or email us at contractquestions@velocitytitle.com. Thanks again for joining us, and we look forward to seeing you again for our next Title Minute.